Okay, so tonight for business law, we are going to go over chapters 12, 13, and 14. We're going to be talking about consideration, illegal bargains, and the impact of minors and things of that sort. When we talk about these things, I kind of touched upon it last time when we spoke. And then today we're going to just go into a little bit more detail. Does anybody have any questions they would like to kind of bring up before we start? No. Okay. We'll move right along then. So, chapter 12 focuses on consideration. And consideration, if you remember, that was the second element when we talk about the four requirements of a contract. If you recall, the first one was mutual assent. And just to kind of recap, mutual assent is that conduct or the words that two parties express to show that they want to get into a contract with one another, and mutual assent is shown by offer and acceptance. Consideration now, which is element number 2, is when each party exchanges a legal benefit or incurs a legal detriment as an inducement for the other party to make an exchange. That's the technical definition. The way I like to explain it is, I think I did that like last week, is you have two entities, right? Two parties that are entering into a contract with one another. Somebody has to give up something and somebody gets something, right? Each side actually has that. Each side gives up something and receives something. So that's the legal detriment and legal benefit. If you're just giving something to somebody and you're not getting anything in return, that's really a gift. So it doesn't have that contractual capacity. It doesn't have the things that tie it and make it into a contract. Why? Because it's one-sided. Don't forget, a contract is an agreement between two people. So the courts do not look at the value that something is placed at. We look at whether or not it's satisfactory to the other side. So if I am selling my phone for $100 and you're going to pay me $100 for that phone, I lose I lose my phone and I get 100, and you lose 100 and you get a phone. So we both lose something and get something. That's the consideration aspect. And like I said, when we talk about the actual exchange, the value, it doesn't matter as long as you have two consenting parties that are okay with that. And the reason why that's important is, maybe I'm selling you my phone, even though let's say it's worth $500 and I'm selling it for 100. Maybe that's because I just need a quick sale. The court's not going to go back if there's some kind of contract dispute later on. The court's not going to say, well, why did you sell it for $100 when it was really worth 500? It doesn't matter as long as you have two parties that agree, understand what the value is, understand what the concepts are, understand and consent to that sale for that price. They're not going to interfere. It's not the court's job to exercise business judgment for valuation, unless there was some kind of fraud or undue influence, which you're going to see, or maybe we spoke about it in the case of Nuke versus Nuke. I can't recall if we already discussed that case or it's going to happen. But unless there's something like that, then the parties are free to contract as they want. So the value is not as important as the fact that two parties are entering into that contract knowingly. When we also talk about consideration, that's when we now talk about a little more detail when it comes to unilateral contracts and bilateral contracts. Unilateral contracts are when the one person is making a promise, and that action or the underlying promise, it's contingent upon something actually happening. A promise is made only by one party. So if I say that I I need somebody to drive me home at the end of class, or I'm going to pay you, $500 if you paint my apartment in its entirety. I'm only going to pay you, and you say nothing. You come in and you start painting. I'm only going to pay you if you start the job. If you don't say anything, if you don't commence the action, it's a unilateral contract. I'm only bound to pay you if you commence that action, if you commence that job, if you commence that task. So it's contingent upon somebody actually taking an action, not a promise for a promise. But in a bilateral contract, you're both sides promising to do something. It's not contingent upon the act itself. As long as both sides are promising to do something, that's what counts. That's what matters. Does that make sense? I'm going to give you a couple of examples just so you get familiar with the wording. Okay, so I'll just give you an example. So I promise to pay you $100 if you promise to paint my house. Other side says, I promise to paint your house. So regardless of whether or not you actually started the job, maybe I'll give you, $50 to start the job. Why? Because I'm counting on your promise. If you now kind of equate it to real life examples, if you ever hired a contractor to do a job for you, maybe painting, maybe the floor, maybe to build a kitchen, what often happens? You put down, anyone want to say anything?
Deposit.
You put down a deposit, right? And then you're going to give them, whether it's in installments or at the very end, you're both entering into this agreement where at the very end you'll get, a portion of your money. Is that a bilateral contract? Is that a unilateral contract?
Bilateral.
Bilateral. Both sides are agreeing to enter into a contract with one another. I say, I'm going to pay you this price, and you say, I'm going to do this job, right? So both sides are making an agreement with one another, and it's not contingent upon the act, although some parts of it may be, right? So the person can come in on day one, can come in on day two. If they don't start the job at all, right? If they don't start, you pay them money or you don't pay them money, but you had entered into it. If you say, with this example, they were supposed to start on January 1st, they don't start until January 5th. Do you still have a contract with them? You do. And you're still waiting for them to start that job because, again, it's not contingent upon the act itself. You both promised with one another. You can sue if that contractor does not commence their job. Whereas if it's a unilateral contract, you can't. If it's a unilateral contract and you say, I'm going to pay you if you come in and do this, if they come in, they get paid. If they don't, then there's nothing there. Then it's a unilateral contract. So if they don't come in and they don't start that job, you don't have anything to go after them. I think that's probably crystal clear right now. Does anybody have any questions? No. Okay. So I'm gonna move on. I generally ask questions on unilateral and bilateral contracts. I give examples and ask you to kind of tell me, is this a bilateral? Is this a unilateral? Or I give you maybe a phrase, a statement, and then ask you select, is it, this or that? What is the best answer? So just kind of keep that in mind. So it's important that you understand the concept. The next thing I want you to know, legal theory, is what's an illusory promise. And an illusory promise is not actually a promise at all. I had, jokingly talked about illusory promises in the beginning when we first started talking about contracts, when I said, it's better to tell somebody that, you will love them for X amount of time rather than to say I will love you forever, because that's illusory. There's no finite time period. It's all hopeful. It's all wishing. It's all desire. There's no beginning and there's no end. So when we have something like that, when we're using the words, wish, desire, hope, it's not definitive and it's not binding. So it's not really a promise at all. And when you equate that to the regular world, or the real world, when a salesperson says to their boss, I promise to sell as many of these, widgets as possible. All right, great. But if you only sold one, can your boss then be mad? No. Why? Because you said you were going to sell as many as you can. And that's why if you're selling, if you're working in an area with sales commission, maybe you have a minimum that you have to sell of a particular item. Why? Because there has to be some way to hold you accountable. There has to be a finite amount. When we deal with merchants and open requirements, and like open output and requirement output, sometimes you don't need a specific amount, but that's when it's two merchants dealing with one another. It's a little bit different when you are dealing with like one person and an entity, or two individuals, or one person and a business. So you need to have that definitiveness. The more definitiveness that you have in a contract, the more binding it is. That's less wishy-washy. There's less room for misunderstanding or mistake. So you want to be able to have as many scenarios as possible kind of played out. And that makes it more of a contract. It makes it more of a binding, and it allows you to kind of anticipate contingencies of breaking that contract and how retribution will be made. So that's an illusory promise. The next thing, which I just actually spoke about, is output contracts and requirement contracts. When we talk about those two types of contracts, again, they mostly deal when it's two merchants dealing with one another, and it's based on the theory of good faith, which is, merchants or companies that are dealing with one another. They're dealing with one another or entering into a contract with one another because they want to. They're not going to try to screw the other side out of whatever it is, because by them entering into this deal, into this agreement, they are mutually being benefited, right? So if you're a restaurant owner and you're entering into a contract with the person who's supplying you, like the fruits and vegetables for a set price, you don't want to screw them, and they're not going to want to screw you. Why? Because they're selling you their stuff, so they're banking on you buying it, and you need their stuff so you can have your restaurant be operational. So you're dealing with one another based on the underlying theory of good faith. So maybe you tell that vegetable and fruit owner, hey, I will buy everything that you have, right? Everything you're able to produce in a month, I'm going to buy. So it's not definitive, but that's okay because it's two merchants dealing with one another. So you have the element of good faith. That contract or that aspect of the negotiation is not going to be invalidated just because a specific amount is not listed there, because that's going to be based on that output contract. What the example I just gave you is actually a requirements contract, which is a purchaser, somebody who's buying, their agreement to purchase a seller's material, right? So I say, I'm going to buy all the fruits and vegetables you have. That's a requirement contract. An output is when the seller says, I'm going to sell you my entire lot to a particular purchaser. Everything I make, I'm going to sell to a particular person. So it depends on the context it's used. Maybe that, that restaurant owner says, I'm going to buy, everything, from you. But that person who has the fruits and vegetables, maybe they have a couple of different restaurants, so they kind of break it between the different entities. I want you to know those terms kind of generally, but not specifically for the exam. Just know that these things kind of exist. Requirement and output just means you're not fine. Those types of contracts, you don't need to have a specific number or delineation. The next thing, this is something I do want you to know. So this is for the exam, write it down moment. And that's what an exclusive dealing contract is. And an exclusive dealing contract is actually something you probably have seen all around you. You might not realize it's actually there. And the best example I always like to give is in the world of CSI. Back in the day when you actually attended school and you would go to the vending machine, did you ever see Coca-Cola and Pepsi in the same vending machine? Think. It's been a
No,
while. Who said no? Who is
me,
this? Me.
Antonio,
Antonio. Do you know why that is, Antonio?
because Because they apparently have an exclusive deal and contract.
That's right. That's exactly right. So, an exclusive deal and contract is an agreement where one entity says, I'm only going to sell your particular product on campus, in a stadium, in a store, whatever it is. So, they're dealing with that one entity itself. So, if you go to, um, perhaps a stadium, like for a sporting event back in the day when we used to attend sporting events, you would be able to see that was probably just one type of thing. Sometimes, even if you go to a restaurant and you say, "Oh, can I have a Coke?" They'll reply and say, "We only have Pepsi." And you're like, "All right, that's the same thing. It's fine." So I don't particularly notice the difference. I don't drink soda that often, but there are some people who know the difference. But maybe that one restaurant or that one stadium or the college campus, they typically have exclusive deal and contract. So they're dealing with that one particular entity. It often happens with phones as well. So when the iPhone 20 comes out, maybe they have a contract with just T-Mobile or AT&T. You'll hear the words on the commercials. You could only find this particular phone, with whatever this provider is. That's an example of an exclusive deal and contract. It's a contract with one entity says, I'm going to be the only provider of this X or this Y. Okay? All right, I'll just, yes. Um, this is a listening, not a writing, although you can if you want to. A modification of a pre-existing contract. Back in the day, you used to have, if you were like modifying or amending a contract, you'd have to have new consideration, something else, an additional term added, or an additional give and take to allow you to amend the contract. But under the UCC, you don't need new consideration in order to amend a contract. Um, so that's just, whatever. This one, I want you to write this down. I might test on it, I might not, I'm not sure. But this is the concept of settlement of an undisputed debt. And this is something you could use in real life. So I want you to know it. So write it down. So let's say I loaned you $100. You paid me back $40 and now you still owe me 60. So then you say, you know what, I'm going to be able to give you the $60 next month, next week. And I say, don't worry about it. It's fine. And you're like, are you sure? And I'm like, yeah. What you want to do is you want to give me something in return or in exchange for that $60 debt. Maybe you say, let me buy you a cup of coffee then, so I feel a little more comfortable. Let me buy you lunch. Let me buy you whatever. Let me give you this pen as a token of my gratitude. You want that give and take, because otherwise you didn't satisfy your debt. Me saying, oh, don't worry about it, maybe I meant don't worry about it for this particular month, right? By you giving me something and I accepting it, you've now satisfied that debt. So that's a little tip kind of for life. It's a something to kind of get out of having to owe that extra thing. So if anybody says, okay, I'm going to forgive you that balance, make sure you give them something. For people who have student loans, and this is a tip, has nothing to do with your exam. In case you have student loans, because it has not been eradicated yet. So, in case you have student loans and after you finish college, or you finish, if you're going to pursue higher education, and you decide to work for public service, there's a program out there that says if you work for public service for 10 years and you pay, the minimum amount on your student loans, whatever you owe at the end will be forgiven. Is it actually forgiven? I don't know. I'm part of that program. It hasn't actually happened for me yet, but the theory behind it is, all right, the balance of your student loans will be forgiven, but it's never really forgiven. Why? Because to the IRS, you're going to say, you get a statement that says this much money was forgiven. So it's now considered like income, almost like you got that money. And so now you have to pay taxes on the amount that was forgiven. So I want to say that's kind of an example of an undisputed or debt reconciliation, because even though A and B had worked this thing out, it's not really totally forgiven until you give something. So once I pay the taxes on this undisputed debt, this balance that I owe, then in fact, I'll actually be fully forgiven. So if you borrow money, if you owe money, just kind of keep that little tidbit in mind.
What if you
Um,
have the relief of the amount, the rest of the amount in writing? Do you really have to go through that, or it's
Oh yeah, you
fine?
still are gonna pay taxes on it, because it's like, I mean, like my accountant, you'll get something from them. You'll get a statement that says this, and it'll tell you to keep it for your records for tax purposes. And so the accountant I work with, he always sends me something called an organizer. It's like a 30-page document with 1,000 questions on it or whatever it is, and so I have to answer it. And one of them, have any loans that you have, have they been forgiven or something, or and so if I say yes, I have to show proof. And then that is going to go to, the IRS, so they can collect, so they can screw you and get
No,
as much.
I kind of know that, but I meant in general, like if it's contract between people, I didn't
Yeah.
mean the student loan part. So if you have that, if the person told you, okay, don't worry about it, and
But
you
isn't
have
that
that in
considered a gift?
writing,
But it's considered a gift, right? At that point.
I
So
mean,
they're
if
they're
you have it in
essentially giving
writing,
it's I think if you have it in writing that they are discharging your obligations for what? Just because they like you? Why are they discharging your obligation? Did you do something to get that done? Did you work it off in another way? Are you going to give them something else? Or just because, for the hell of it, they are going to? It makes it a weaker argument when you're not giving something in return for that forgiveness of that debt. So you could have it, you should certainly get it in writing to bolster, but if they kind of change their mind and say, I didn't get anything in return, that was a gift, I want it back, maybe they'll be able to succeed on those merits. Okay. Next thing is past consideration is not consideration. So if you do something nice for someone and then they say, "Oh, we'll get you back. Don't, I owe you one." They don't actually owe you anything because you've already performed that act for niceness. What you want to do is, if you're going to do a favor for someone, before you do the favor, you should say, "I'm going to do this for you. I want something in return." And then it's no longer, now it's kind of, again, it's consideration. It's one for the other. You should be starting to see a pattern here, right? This is the whole thing of consideration, tick for tack kind of thing. So if just because somebody took care of something for you or you took care of something for somebody, it doesn't mean that you'll actually be able to collect on that past debt. Um, this is a listening third party consideration. Sometimes you can negotiate with, can have a negotiation between two parties, but actually involve a third. So if I enter into a contract with somebody, I'm purchasing a car and I'm buying the car from a private seller. I want to pay $10,000 for the car. Maybe I need a bank or a mortgage, not a mortgage, a bank or a financial institution to help me with that payment. I'm going to put 2,000, but I'm also going to involve this third party so I can borrow money from them so that I can pay this person. So that's kind of the involvement of a third party. So sometimes those types of contracts are also valid.
it's like
Uh,
co-signing someone.
say that again.
It's like co-signing someone.
Yeah, co-signing somebody also. Absolutely. Yeah. Um, yeah, the last thing I want to do for this chapter is a firm offer. And this is a listening. A firm offer, when it's done by a merchant, it's not revocable. It's as long as it's done, or the action that's going to be performed is not going to take longer than 3 months. That's just, it's in the books. I'm kind of telling it to you, but not that important. What I want to do actually is I'm actually going to tell you the secret phrase before I forget. Where's my secret phrases? Okay, let's see here. March 15th, 2021. This is Monday night. Monday night. Okay. The mouse moves faster than the owl at midnight. The mouse moves faster than the owl at midnight. One more time, the secret phrase for tonight's attendance. The mouse moves faster than the owl at midnight. Okay, let's resume. Now we're going to move on to chapter 13, which is illegal bargains. Oh, yes, somebody just wrote, any gains are always taxable, no escaping taxes. That's correct. I hate taxes. We all hate taxes, right? But it's something we have to do because it's the society that we live in. So, chapter 13 is illegal bargains. I find this chapter very entertaining because it's just, that's what it is. Remember what we talked about, element number 3. We said that, requirement number 3 is whatever you're contracting over has to be legal. If it's not legal, you can't then go to the court and say, oh, this person breached their contract, I want to sue them. Why? Because you were contracting over something illegal that you should not have been contracting over in the first place. So when we talk about that, some things that may be perhaps legal or could be illegal depending on how it's done. And the example I think that's in the book and that we are going to talk about for a few minutes is gambling. Some types of gambling are legal and others are not. Which ones are legal?
The ones regulated by the state or the
Yeah.
government.
So that's
Those are
strict to the
legal.
textbook. That's right. Christopher, what were you saying?
The same thing, something that's done in like a licensed, registered
Yep,
casino.
exactly. A licensed registered casino. Something that's monitored, people are putting in something that's monitored in some way. And it's really something that the government has a hand in essentially is legal. And if they don't, then maybe it's not legal. So if you are, during football season and I don't know, maybe basketball, they have all those pools and stuff. Are those legal? Are they not legal? So if you have, somebody who's collecting the money, collecting the pool, and then it's mandatory to give them, it's not mandatory, but it is, if you don't pay them their percentage or whatever, if you win, then there's a problem. There are, some types of gambling where if you don't pay up, you'll have broken bones at the end or your life may be threatened. Those are certainly not legal in nature. And so those are not good. There's actually something that I'm going to tell you about because I remember doing a lot of research on this, and that's certain loans that you take out. And I don't know if that's really, it's not really under the gambling, but something to kind of keep in mind. And there are certain loans that you take out, and then you have to pay a high percentage of interest on them. The law governs, how much interest. And if it goes past a certain level, then it's usury. And so they're not legal in nature, and so they should not be actually happening. I used to I helped start a company back in the day that was a litigation funding company, and what that company did was, if you might see commercials now, but the commercials are certainly not as much as they used to be. For people never get a payday. Yes, big, thank you, that's good. Big scam. So if you had a lawsuit but you couldn't wait to collect the money at the end, these companies would say, all right, we'll loan you $10,000 today, and when you get your money, we're going to get this much back. And they would give you a schedule, but they would tack on the origination fee, the processing fee, the underwriting fee, and the interest would compound on those loans. So you are borrowing $10,000, you are paying back a tremendous amount. And one of the things I had to research was whether or not that's in compliance with the usury law. And the reason it was in compliance was it was not a absolute like 100% that a case was going to recover assets. And so because it had that contingent factor where maybe this case wasn't going to get anything, it surpassed usury laws. Like it would not invoke it. And so companies like that were able to charge a ridiculous amount of interest. But on paper, the interest didn't really seem like it was that much. But because it compounded, it was ridiculous. So I would always tell people on the phone who were like calling to get this, don't do this unless you absolutely need this. Don't do this if you have any other choice. Go talk to your friends. Go see if you can borrow money from anybody else before you do this, because it's a lot of money. So then now you get your recovery, and you're paying a ton of money because you're selling a portion of your interest on that case. So it's yeah, it was legal. It was legal. What else do I want to tell you about legal and not legal? Okay, so there are certain types of licenses that are also there because they're protecting the public from unqualified practitioners. So regulatory licenses are there to protect the public. So doctors and lawyers, they're supposed to have some kind of license that makes them qualified to do whatever it is that they are doing. There's also something called licensing statutes, and those are like the plumbers, accountants, nail technicians. They're also trying to show that some kind of standard is being met that's there. Contractors, some contractors are licensed, others are not. When you are hiring somebody, sometimes perhaps a person who's not licensed has cheaper rates. But if you're going to sue, who do you have a better chance of collecting against? Somebody with a license or somebody without?
With a license.
With a license, because then it's the court's going to ask, well, you did this on your own, why didn't you hire somebody licensed? Because at least then they're legit, they have some kind of experience, or they have something with the state that you can go after. But if you're going after somebody who's not licensed, you're certainly getting maybe a better deal, but you're losing your what if, where I like to say it's your what if. So what if you have to sue? Like my husband, he's a physician, right? He's an OBGYN. He wanted to deliver both our children. I said, but what if I have to sue you? I can't do that if you do the delivery. So he was a resident the first time. So I had my regular physician. So he was certainly involved, but like, that's automatically where my brain goes. What if I have to sue? Anything that we do, what if I have to sue? Who can I go after? Because that's just a lawyer. And I'm certainly not a litigious. I will tell you, like, there's certain things where we do have rights and you can sue and blah, 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 but I don't always go for it because cases, it doesn't matter who you are. Cases in the court system take a long time. It's a big legal process. So you don't want to sue for every tiny little thing, but you also want to be able to just have that right to be able to do so if you need it. What else do we have here? Revenue, gambling. Okay. Employment contracts. This is something you should know. This is something you should write down because this is also important for your livelihood. And when we talk about employment contracts, what I want you to know is what a restrictive covenant is. And it's important. And I'm going to actually use my little whiteboard here. So okay. I don't know where you all are right now, but like since this is Staten Island and you're attending the, College of Staten Island, I'm going to make a map of Staten Island. Okay. So College of Staten Island is right here. Let's say you're going to actually start to work in the College of Staten Island, but the College of Staten Island gives you a contract and they say, if you work for us, and the College of Staten Island would never do this. So let's say you work for an accountant firm right where Staten Island is, CSI. But they tell you, listen, we're going to hire you. And in your contract, it says you are not allowed to work for a radius of, 15 miles. So what does that actually mean for you? That it's a radius of 15 miles. Staten Island as a whole is not 30 miles wide. I don't know how much it is, but it's not that much. So it's actually, right? It's preventing you, huh?
It's 30
It's
mile.
preventing Yes, if somebody wants to Google it, and I'll change my numbers accordingly. But when you do whatever the numbers, I can even make this 25 to be on the safe side, 25 each, right? 25 miles. 25 miles, maybe not be that much, really. But for Staten Island, now it's what is it also doing? If you're not allowed to work within a 25-mile radius, 50-mile diameter, where is that also preventing you from working?
New Jersey,
New
Manhattan.
Jersey, Manhattan, Brooklyn, right? That's a lot of restriction on you as an employee. So is that actually a fair practice? When you live in a town or a city that's heavily condensed and so close to other areas, a 50-mile diameter is really a big deal. If, however, you worked or you lived in, Montana or Nebraska, and yeah, you were here working and they give you that 50-mile, you know what? 50-mile, it takes you 50 miles so you can go get a gallon of milk somewhere, right? So it's not really a big deal. So it depends on where you're actually living and what's around you. A restrictive covenant is not just with mileage. It's actually with competitors. It could be years. You're not allowed to work for a competitor for 1 year or 2 years. So when you are gainfully employed, maybe you are now, I don't know, whenever you're presented with a contract for employment, make sure to look and see whether or not there's a restrictive covenant clause in the employment contract and negotiate it, because you don't want to be in a position where you're precluded from, being gainfully employed and having a fulfilling life as whatever type of employment you're going to have because of that restriction. I remember one of the first places my husband worked in, he had a contract and it had a restrictive covenant. It said that he originally had like 10 or 15 miles that he couldn't work for that type of facility. And I'm like, look on a map, look at it. You're actually not going to be able to go to Brooklyn. Like, you're not going to be able to. So, and Brooklyn's right over the bridge. That's something that's needed. So that was something we were able to negotiate. That way it could kind of make more sense for you. So keep that in mind. That's a restrictive covenant. It applies to mileage. It applies to years. It applies to, competition, competitors, and things of that sort. So be on the lookout for that. The last thing for this chapter is corrupting public officials. That should be kind of go without saying. You cannot do that. You cannot offer public officials bribes. Don't do that. That's wrong. You're not allowed to do that. Do not think that you're going to offer, money for something and expect something in return. A public official works for you. Their job is to represent your interest. That's why I'm very, very big on getting involved in your community. I don't care your political affiliation. I said this before, I will say it again. Get involved in your political party, regardless of which one it is. I have friends on both sides. If you actually have an interest, let me know and I'll hook you up. If there's a particular campaign there's a lot of people petitioning now for things if you're on Staten Island. So if there's a particular candidate you feel strongly about that you want to support, maybe you can go volunteer. Learn how the process works. Be involved in the process, but do not offer bribes to anyone. That's bad. Don't do that. Does anybody have any questions before we move on to chapter 14, which is contractual capacity? All right, we'll learn along. So chapter 14, contractual capacity. That is, it goes both ways. We talk about minors, right? And we talk about persons with developmental intellectual disabilities. So when we talk about a minor entering into a contract, minors are really actually in a great position, and people don't know this, until usually you're past the age of being a minor. So a minor can enter into a contract and they can, make that contract voidable if they want to. They're the only ones that can do it if it's like a contract between a minor and an adult, unless it's for food, shelter, clothing, and medicine. Those are things that are necessities. And so if a minor enters into a contract for one of these 4 things, it's still going to be binding. But let's say a minor enters into a contract with a car salesperson, and they decide they're going to go in and they're going to lease, or yeah, like, the one that you use the car for a couple of years and then you have to give it back, a Ferrari. And the person who is on the sales floor enters into a contract with them for that, and they're 17 at the time. Let's say they start making a couple of months payment and then they default. Like, that's on the salesperson. Why are you they can, and they have the car, so you just gave a car off the lot, and that's not going to, they can void that contract. You're not going to be able to enforce that contract against them if it's for a Ferrari. If you're able to show that it was like a Toyota where they needed that particular vehicle so they can get to work, and they were maybe emancipated or things of that sort, then maybe you have a chance at enforcing that contract. But otherwise, it's not valid, and it can be voided at the minor's option, and you'll be screwed if you kind of entered. And aside from that one caveat, where if it's for those 4 things, if the minor ratifies that contract after the age of 18, then it can stand. And the case that will also show us this wonderful example is the case of in Ray Scoreboard. Who wants to tell me generally in your own words what this case was about?
I can go. If someone
Hold on,
doesn't.
I want to see if anybody else. Is anybody else reading besides Omar? Anyone? In Ray Scoreboard. All right, Omar, go ahead.
So Kobe Bryant, he decided at 17 years old to forego the college and to join the NBA. And then there was this company that they used to make like trading cards for sport entertainment. They went into a contract with him, actually with his father and with his agent when he was still 17, that they were to produce some of those trading cards with his picture on it. And then he has to make physical appearance on their behalf, and then he would sign like between 15,000 to 32,000 autographs, and he would get like $2 per autograph after the first 7,000 ones. And then he so he started, sorry, he started the contract. Yeah, he started like the contractual agreement, and then he started signing and everything. And then he started getting famous, so he didn't like the terms, and he felt that he would deserve more money. And then they tried to negotiate the agreement, and then he wrote some new terms, and then he sent it to the agency, to the company, sorry. And then that company didn't sign it back and send it back to him. They said that they signed it and put it in his file. But on the proceedings, they didn't show that. They showed only the one that's signed from his part. But then he would get $10,000 as a base payment on those services. So what happened is, after he turned 18, after 3 days of him getting 18, he deposited the $10,000 check. And then the company started having financial crisis. And then when they filed for bankruptcy, they started like selling their assets, including the contracts with the players. And he was in between them as well. So he said that they don't have the right to sell his contract even because they don't have a contract initially. And then, but the court said that, well, he ratified his contract by him first keep doing the autographs and the appearance, second by depositing the check when he reached the age of 18. So the court ruled out in the other company's favor.
That's it. You hit on the most important aspects of this case. He had entered into a contract when he was a minor. He's trying to get out of this contract, except after he turned 18. He continued to perform the actions within the contract, and he deposited a check that came from this company based on the contractual agreement. By doing those 2 things, He, in fact, ratified the contract. He might have been able to get out of it, but once he turned 18, he ratified it. Once you ratify it, you can't then say, oh, I take it back. No, now you can't use that whole thing of, oh, I was a minor, I can get out of it. It's too late. You're now the age of 18, you're a consenting adult, you ratified it, now it's going to be binding. Very good. Excellent. Excellent, Mar. What else do we want to tell you? Okay, liability. I talked about the liability for necessaries, food, shelter, medicine, and clothing. That a minor is always going to be responsible for. And then we're actually only have a couple, like 2 other things, and then we'll be done. Persons under guardianship, right? If somebody is mentally, intellectually disabled and you enter into a contract with them, don't forget that is void and there's no legal effect. If somebody enters into a contract and they kind of, not so much the intellectual developmental disability, but let's say they were intoxicated at that time and so they signed it and they didn't really know what was happening, it's a voidable contract. They can actually void it. They're the innocent party. They didn't know what they were doing at that time. So they have the option of canceling that contract within a reasonable period of time. Right? So let's say you went to on the golf course, you went to a dinner or something, and you got, hammered completely, and you signed off on this document, and you didn't even realize it, but you realized it a day or 2 later when you've kind of come to your senses. Well, you can invalidate it because at the time that you entered into this agreement, you did not know what you were doing. Again, don't forget the underlying thing that 2 people who are entering into a contract are doing so because they want to enter into a relationship with one another. If one person doesn't want to do it, and the other side, forces them to enter into this contract because they signed, even though they didn't have all that clarity, what are you going to have? You're going to have a disgruntled person. And so if you're, dealing with them that they're supposed to be manufacture a certain thing or provide a certain service, they're not going to be happy doing it and they're going to screw it up. And so you're not going to be getting what it is that you're expecting to get. So it's better to always enter into a contract with somebody who's willing and able to. That way it's a mutually beneficial agreement. So somebody who doesn't have the wherewithal, not a good idea to get them to sign on anything because they'll be able to get out of it in a reasonable period of time. So that's really the mental illness and intoxicated thing. You want to act promptly to void that contract if you are intoxicated or you're inebriated or whatever it is. You want to do it in a reasonable period of time. You can't wait 15 days, 30 days, and then try to do it, because then the court could say, well, you realized that you should have done this and you did not. So then it's kind of on you. Does anybody have any questions? Because that basically concludes the class for tonight. Let me see here, 15. I think next week, let's see. Next week, we're going to do chapters 15, 16, 17, and 18. And then the week after that is our exam. So
I just didn't understand the part where it's like the incompetent person about the guardianship one.
So when somebody is intellectually disabled, they don't have any mental capacity to enter into a contract. That, if they sign off on anything, that's actually void, not voidable, because you have to have that requisite mental ability to know and understand the nature of the agreement. So it's different than when you are, regularly you understand things and then you had a moment of, or a couple, a time period where you were not focused, maybe you were dehydrated and you started hallucinating, right? And you didn't know what you were doing. So then that's a problem at that point.
Yeah, but what's the guardianship word
So
in
if
this?
somebody is has a guardianship, a court appointed guardian, that person can enter into contract on behalf of the ward because it's in their benefit. The ward themselves can't do it, but their guardian can.
Okay, yeah, that's what I needed.
Yeah.
Thank you.
You're welcome. Any other questions? Okay. So if there's nothing else, have a great night. I will post this because we didn't have any interruptions tonight. And so I will put it on your Blackboard probably today or tomorrow. Have a good night, all.
Good night.